Welcome to the National Bar Association, the Women's Bar Association, the Bar Association of the District of Columbia, and the Metropolitan Washington Employment Lawyers Association's September webinar, Workplace Diversity After Students for Fair Admissions. I'm Scott Oswald, MWELA's Bench and Bar Chair, and I'll be your moderator for today's program. Before we begin, Wiley Adams, Mary Blatch, and Rawle Andrews Jr. have introductory remarks for us. First, Wiley Adams from the National Bar Association. Wiley?
Thank you, Scott. As Scott mentioned, my name is Wiley Adams. I'm the 82nd president of the National Bar Association. And on behalf of the Bar Association, I'm so happy that we're able to play a role in today's presentation with a top-notch panel and a cutting-edge topic, workplace diversity. Allow me the privilege to say just two quick pitches for the National Bar Association. First, we represent the interest of the 67,000 Black lawyers and judges throughout the country. We are a bar association, but we are also a social justice organization whose mission is to, among other things, advance the science of jurisprudence and to improve the administration of justice. We are also at a very important point in our history. That is, in 2025, the NBA will turn 100 years old. So we will be celebrating our centennial, and we will host that centennial celebration in Chicago, my hometown of Chicago, Illinois, from July 26th through August 1st. Hope to all see you there. And if you're not a member, please sign up. And with that, Scott, I will turn it back to you.
Wiley, thank you. Next to Mary Blatch from the Women's Bar Association. Mary?
Thanks, Scott. I am the president of the Women's Bar Association of the District of Columbia. We call ourselves WBA. We really appreciate the opportunity to support today's panel. It's such an important topic for our members. And we just want to thank MWELA and the NBA and BADC for MWELA for organizing the panel and the other bar associations for their support and sponsorship. WBA is one of the oldest women's bar associations in the country. We were founded in 1917 by two suffragettes who were not allowed to become members of other bar associations in the city. Our mission is to maintain the honor and integrity of the legal profession, promote the administration of justice, advance and protect the interests of women lawyers, promote their mutual improvement, and encourage a spirit of friendship. We do that by offering our members, as well as others in the city, networking opportunities, programming that supports their careers, gives them the opportunity to participate in planning and speaking at events, and contributes to the wonderful legal community we have here in DC. We also have an active, very active advocacy committee that addresses women's issues in the legal profession and beyond. Later this month, we're going to be hosting our annual Stars of the Bar event, which I want to invite anyone to attend if WBA sounds interesting to you. This is a networking and awards reception where attendees can learn about the WBA, our upcoming programming, meet our board members and committee co-chairs, and just get more involved with our association. This event will be held September 19th at the DC Bar headquarters, and you can find out more about the event and about WBA at our website, wbadc.org. Thanks, Scott.
Mary, thank you. And finally, Rawle Andrews Jr. from the Bar Association of the District of Columbia. Rawle?
Thank you, Scott, and my fellow co-sponsors of this very timely event. It is often said, but even more often observed, that while talent might be equally distributed, opportunity is not. So today is a unique opportunity to talk about unconscious bias. It's a fantastic opportunity for us to explore the depths of imposter syndrome, what rock star bias is doing in our workplace, and what surfaces underneath the depths of what it means to be in the legal profession. Since 1871, the Bar Association of the District of Columbia has continuously operated inside the district and beyond to merge the intersection of law, policy, and community. We have done that through advocacy. We have done that through community outreach, and we have done that through collaborations with organizations like MWELA, the National Bar Association, the Women's Bar Association of DC, among others. We have a couple of key events and one key announcement that I want to make today. We will have our annual judicial reception at the Judge William Bryant Annex of the U.S. District Court on September 30th. At that time, we'll be recognizing retiring and new judges at both the federal and the local courts. Again, September 30, 6 o'clock in the federal courthouse in the Bryant Annex. On December 7th, we will have our annual banquet. We're well over 150 years old now. We will be recognizing some tenured professionals and rising stars. I'm breaking news today to tell you that Elaine Jones, formerly of the Legal Defense Fund, will receive the Honorable Anise Wagner Pioneer Award. I'm privileged to tell you that Shirley Aniguchi, former DC Bar President, and now my successor as President-elect of the BADC, will be named Lawyer of the Year. And then we have one of our Young Lawyers of the Year, Sanchita Bowes from Hogan Lovells, who will be named the Young Lawyer of the Year. So we want you to join us at the Capitol Hilton, our home away from home for the BADC, on December 7th. If you want more information about what we do and how we do it, www.badc.org. Thank you very much, Scott. It's a privilege to be here and to thank you for your leadership, as well as our esteemed chair of the EEOC, as well as Judge Edelman and panelists for this program.
Rawle, thank you. Now to our participants in today's roundtable. Charlotte Burrows is the chair of the United States Equal Employment Opportunity Commission. Prior to joining the commission, Chair Burrows served as Associate Deputy Attorney General at the United States Department of Justice. Charlotte Burrows' opinions expressed today are her own and don't necessarily reflect those of the U.S. Equal Employment Opportunity Commission. Todd Edelman is the presiding judge of the Civil Division of the Superior Court for the District of Columbia. Prior to joining the court, Judge Edelman served as a trial attorney at the DC Public Defender Service for the District of Columbia and as an attorney with the law firm of Bredhoff and Kaiser. Todd Edelman's opinions expressed today are his own and don't necessarily reflect those of the DC Superior Court. Jocelyn Cuttino is a partner at the law firm of Morgan Lewis. Jocelyn is the founding member of Morgan Lewis's multidisciplinary workplace consulting team, where she helps employers address allegations of non-inclusive work environments. Maya Jefferson is an attorney with the law firm of Gilbert Employment Law. Maya represents employees under Title VII of the Civil Rights Act of 1964, among other employment laws. I'll take your questions throughout the discussion portion of today's program. Just use the Q&A button located at the bottom of your Zoom screen. Let's begin with a primer from Maya Jefferson on the status of diversity, equity, and inclusion initiatives in the aftermath of Students for Fair Admissions. Maya, over to you.
Thanks, Scott. So first, we thought it would be helpful to make sure we were all on the same page about what DEI means. Of course, DEI stands for Diversity, Equity, and Inclusion. And it is an organizational framework, practices, and or initiatives that promotes pragmatic efforts to increase the workplace's ability to embrace the differences between employees and what they bring to the table, whether those differences include someone's race, age, ethnicity, religion, gender, sexual orientation, physical or mental ability, or other aspects of social identity. It increases a workplace's ability to provide equal opportunity, and then it increases a workplace's ability to respect everyone's voice and create a culture where people from all backgrounds feel encouraged to express their ideas and perspectives. Now, why might employees and employers want to implement these practices or frameworks for business purposes? Next slide, please. Democracy Forward recently published a wonderful paper that surveyed DEI initiatives and discussed how and whether the Supreme Court's affirmative actions decisions have begun to affect education and workplace landscapes. They noted in their report first that DEI initiatives increase profit. Research from Deloitte, McKinsey and Company, and Harvard Business Review, Forbes, and more all highlight the same thing. More diverse and inclusive companies are more and therefore more profitable. A research report by Deloitte found that organizations that establish inclusive cultures are twice as likely to meet or exceed financial targets, 3 times as likely to be high performing, 6 times as likely to be innovative and agile, and 8 times more likely to achieve better business outcomes. Finally, the Harvard Business Review found that companies in the top quartile for racial and ethnic diversity are 35% more likely to have financial returns above their respective national industry medians. So we can see why the Supreme Court's decisions would be a salient topic to discuss today, not just because of the potential effects that change in diversity initiatives might have on employees, but also on employers and American businesses and organizations, including law firms. Next slide, please. And a little overview about the Supreme Court's decisions that we're here to talk about today. In 2023, the Supreme Court held that Harvard and UNC, and by extension, any other university, could not use race as a factor for admission. Specifically, the court stated that the universities failed to demonstrate their compelling interest in a measurable way. They failed to avoid racial stereotyping and did not offer a logical endpoint for when race-based admissions would cease. The court explained that while the school's efforts were quote unquote well-intentioned, the benefits of having race as a factor were not measurable. However, the court's ruling still allows colleges to consider how race has affected a student's life and their ability to contribute to educational institutions. Next slide, please. So we looked at a couple of cases after SCOTUS's decision. Next slide, please. And we pulled out some theories of the cases and some kind of high-level takeaways. The first, before we talk about those cases, are that DEI trainings can include pedagogy that promotes racial inclusion, but it cannot specifically pit one race against the other, even if there is historical context. And I'm using the word pits here, not specifically because I believe it's appropriate, but because I think it matches the tone of the plaintiff in the next slide that the plaintiff took when describing trainings that specifically included a historical narrative about what one race did to another and its importance. And I think it's an important point to be sensitive to the narrative to avoid suits. The second was that trainings and frameworks cannot be used to change the demographic makeup of the workforce. And finally, DEI initiatives and trainings can be considered not just as context for actions of the alleged discriminating official, but also as evidence of racial animus. Next slide. So one of the cases that we reviewed was Young v. Colorado Department of Corrections out of the 10th Circuit. A white male former employee claimed that the Department of Corrections training materials for its equity, diversity, and inclusion programs subjected him to a hostile work environment by, among other things, stating that all whites are racist and that white individuals created the concept of race in order to justify the oppression of people of color. The court dismissed the case for failure to state a claim, and the 10th Circuit affirmed, holding that the plaintiff had failed to allege that the DEI training, which only occurred once during plaintiff's employment, constituted severe and pervasive harassment. I think it's important to note, though, that the court did state the following, that Mr. Young's objections to the contents of the EDI training were not unreasonable. The racial subject matter and ideological messaging in the training was troubling on many levels. As other courts have recognized, race-based training programs can create hostile workplaces, and when official policy is combined with ongoing stereotyping and explicit or implicit expectations of discriminatory treatment, the rhetoric of these programs sets the stage for actionable misconduct by organizations that employ them. So although the case was dismissed, I do think it's important to note that the court kind of highlighted that the training only occurred once, which to me emphasizes that maybe if this training had occurred quarterly, the outcome of the case may have been different. I also think the quote I read below is important to remind employers to be careful about how you craft the historical narrative that supports your programs. Next slide, please. And finally, we have the Duval v. Novant Health Inc. case out of the Fourth Circuit in North Carolina. This was an interesting case, and I encourage people to look it up and read it. So a white male marketing executive claimed that he was fired without cause from his management position because of his race and sex. At trial, the plaintiff relied on evidence that Novant maintained, quote, a goal of remaking the workforce to look like the community it served, which I know a lot of us have heard that before, and argued that his firing fits a pattern of similar actions by Novant. Novant appealed to the Fourth Circuit, which affirmed the district court's refusal to enter judgment as a matter of law because, quote, there was more than sufficient evidence for a reasonable jury to determine that Duval's race, sex, or both motivated Novant's termination of him. This evidence included that the plaintiff was, quote, fired in the middle of a wide-scale D&I initiative, and that initiative sought to, quote, embed diversity and inclusion throughout the company, including by employing D&I metrics, committing to adding additional dimensions of diversity to the executive and senior leadership teams, and incorporating a system-wide decision-making process that includes a diversity and inclusion lens. The court spent 5 pages providing the context of the D&I initiative, why it was formed, how it was formed, and what the goals were. And I think it's just very important to note how much time they spent kind of outlining how that initiative came to be. And a final note that I also found very interesting about this case is that Novant implemented financial incentives for diversifying the workforce, but it argued that evidence of these race-based bonuses were irrelevant because the financial incentive plan was not formally adopted until after Duval was fired. It also argued that the bonuses related only to furthering the goal of increasing Hispanic and Asian workforce, a goal that would not have been furthered by Duval's firing because a Black woman was his replacement. However, the court stated that it did not think that either of those facts would preclude a jury from properly considering this evidence. And the court reasoned that the incentive was all part of the same D&I plan, and a jury could reasonably see these race-based bonuses as a formal recognition of a pre-existing policy using race in decision-making. So another takeaway, in addition to the one listed above, is that diversity efforts that seek to increase the population of one race in the workforce can be used as strong evidence that an employer seeks to alter the racial makeup of the workforce regarding another race as well. And with that, Scott, I will hand it over to you.
Maya, thank you. And for all those listening in, we will circulate Maya's slides to each of you after the program. Let's begin the Q&A portion with the management side perspective of corporate workplace diversity initiatives. Jocelyn, I'd like to begin with you. From your perspective in representing companies, are workplace diversity, equity, and inclusion initiatives good for companies?
Thank you, Scott, and it's great to be here today with everyone. They are absolutely good. I think that what we have seen from the research over the years, and I think Maya quoted some of it, is that companies perform better when they have diverse leadership and diverse workforces. There's no doubt about that any longer. But I think some of the buzzwords around DEI have changed and have been misconstrued to suggest that it means other things that it does not.
Thank you for that. Chair Burrows, I'd like to toss a question to you. There is some research that suggests that DEI initiatives not only promote a more diverse workplace, but make companies more innovative and competitive. Do you agree?
Well, thank you for that. And I'm so glad to be able to join all of you to talk about this really important and timely issue. So, yes, I do agree with that. And many employers have shared with us that promoting DEIA is good for business. I will say, as the head of an organization with about 2,300 people, we have found we naturally attract a very diverse workplace. And not surprisingly, we found that to be our experience as well. The research shows that diversity efforts help attract top talent, spark innovation, improve employee satisfaction, and help them better serve diverse communities. So that's why the EEOC's recently approved strategic plan, as well as our strategic enforcement plan, specifically emphasize that this agency will continue to promote diversity in its own ranks and serve as a model employer so that we can best serve America's increasingly diverse population of workers. And of course, it's a priority throughout the federal government as well.
So for companies who haven't already implemented a DEI program, and of course those that have but maybe are considering pulling back, what message in your personal capacity do you have for them?
Sure. So what I would say about that is that, as you've heard, there's a lot going on in this space, both in terms of the public, but also in terms of the courts. And so I think the big picture takeaway is that DEI programs can help remove barriers so that companies and our economy can really reap the benefits of having employees who can contribute to new approaches to problem solving and better serve diverse customers and consumers. And companies that are competing for top talent really can't afford to leave talent on the table when recruiting. I know we don't do that if we can possibly avoid it at the EEOC. In addition to the benefits that you get out of, from a business perspective, out of DEIA. And I should say, we at the agency talk about diversity, equity, inclusion, and accessibility. So that's the A, with respect to disability as well. These policies can help reduce legal risk. Evaluating your workforce and addressing barriers to advancement for underserved groups can really help employers ensure that they're not violating laws, either federal or state anti-discrimination laws. And we heard earlier about a couple of the lawsuits in the PowerPoint. And one of the things that I think is important is that underlying all this, and we're going to get into some of the details, is really that you have to have a well-constructed and thoughtful DEIA program. And I think that these are some of the examples that, may not fit in that box, to say it mildly, certainly in the Duvall instance. And one of the things that I thought was important, though, is that both of those decisions make it clear, and Duvall actually has a footnote, I think it's footnote 10, that goes into detail saying, look, we're not saying that you can't have a DEIA program, or D&I, I think is what they referred it to. What we're saying is you can't use it as an excuse to discriminate. And so what that means, you can see what you can't do from the decision is sort of just decide you're going to fire, your white employees so that you can bring in other folks, but who are less qualified for that. But the important, I thought, of that was that the court really didn't have to go out of its way to say that, and they wanted to keep that clear. And it's clear also from the Colorado decision, the 10th Circuit decision, rather, that that's the case as well. And so, there's some nuance here, and we will get into the details, but which is one of the reasons why I'm happy for this opportunity, because I think it's important to be focusing on exactly what we're talking about with respect to DEIA.
So in the immediate aftermath of the Supreme Court's Students for Fair Admissions versus Harvard decision, you stated rather emphatically, it remains lawful for employers to implement diversity, equity, and inclusion programs. There's been a lot of activity over the last year. Is that still the case today?
Yes, absolutely. And while the SFFA decision really raised the focus and the attention around DEIA programs, there's not actually been a change in the law in this area. The SFFA decision did not affect existing employment law. The Supreme Court's decision involved really equal protection and Title VI challenges to affirmative action programs in the university admissions context. And so there's a really important doctrinal decision between an analysis of diversity in higher education that is expressly race conscious in that instance versus DIA programs in employment. And so the cases did not involve employment discrimination claims. The decision did not address employer efforts to remedy the effects of past employment discrimination or foster diverse and inclusive workforces or engage the talents of qualified workers from underserved communities, all of which are relevant in the DEIA, most DEIA programs. And so when structured and implemented properly, and we should emphasize properly, DEIA initiatives are fully consistent with federal anti-discrimination laws, which our agency enforces, and they can benefit employers and a variety of workers of all backgrounds. So this actually is not a time for employers to pull back, but it is an important time to re-examine existing DEIA programs. And so as a majority of this commission, which is charged with enforcing Title VII and all of the other federal anti-discrimination laws, a majority of this commission has recognized that this issue is enormously important to the future of our country, to the success of our economy, and the strength of our democracy. And so this year, we actually released 3 commission-voted documents that I want to make sure you're aware of, 2 amicus briefs and a federal sector decision. And I'm flagging them because as rich as I know our conversation will be, we probably won't get into the same amount of detail. There's some things that you really want to, as lawyers, you need to be written out. So in this area, to help employers really understand how to engage in DEIA practices lawfully, if you look at where these commission-voted documents are, the 2 amicus briefs and the federal sector decision sort of outline our positions in a lot more detail than I'm able to get here today. The Vavra v. Honeywell is one of the decisions. It dealt with a training program and allegations about it. And the issue there was really whether or not it's per se unlawful to be engaging in DEIA training. And the answer from the Seventh Circuit was no. And so both our brief and, of course, the court's decision sort of explain that in more detail.
Sure, Burrows, thank you. Jocelyn, let's bring you back in. I mean, you're on the ground, you're advising companies on a daily basis on these subjects. Has the Students for Fair Admissions case impacted corporations' appetite to begin or continue corporate DEI initiatives?
I do not think those decisions have impacted the appetite. I think they've impacted the way that companies go about achieving those goals. I 100% agree with Chair Burrows, as is normally the case, that companies have been steadfast in their commitment to achieving equity and a diverse workforce. But the way they go about doing that has changed. And, I agree that the SFFA decisions did not address employment, but the challenges that have resulted from those decisions from anti-DEI groups, those are what have had the biggest impact. We've certainly seen that employers still want to pursue their DEI goals, but they want to do that without the threat of expensive litigation. That threat is often prompted by some of the language used for certain programs that is publicly available. But there are certainly ways to adjust the programs so that they pursue and achieve some of the same goals without being subject to expensive litigation or challenge.
So let's take our first question from the audience, and it is, do you think that companies currently pulling back on DEI initiatives, there are some examples here, Harley-Davidson, Home Depot, are doing so because of the decision itself? What do you think, Jocelyn?
I mean, is there a natural flow from the decision itself? Possibly. But I think it is the challenges that are flowing from those decisions that are resulting in pulling back. And I also think it is very much how some of the programs have been misconstrued that's having an impact as well. One thing that we've seen from some of the anti-DEI groups is this idea that a diversity, equity, inclusion program means hiring people who are less qualified for positions. And we know that it absolutely does not mean that. But I think when that is pushed as the narrative, or these programs are characterized in that way, then certainly there's going to be some pullback from that. There's going to be pullback to avoid some of those challenges. But I think we have to think about how we design these programs so that they accomplish the same goals, but don't run afoul of the law. And don't invite the challenge that we've seen to a lot of the programs. And we can absolutely do that. Companies have done that. But I think it's about the buzzwords and the challenges that are being invited, and really not about the goals themselves.
So Chair Burrows, after the Students for Fair Admissions decision, from your perspective, is it appropriate for employers to re-examine their DEIA programs?
Absolutely. I think it's important to make sure that the DEIA programs that one has put in place are thoughtful and comply with the law. That doesn't mean, and as any other, frankly, any other program that a company might adopt that is important for profit and loss. So not limited to DEIA programs, but certainly in this context. And as you mentioned, there's been, I think, in the wake of the decision, quite a lot of confusion. And, so there also may be just a need to re-examine the messaging, both internally and externally, because quite frankly, it's better to just really understand kind of how what you're saying is landing. And so I think that is, the gravamen of it, and certainly what I would advise anyone to do if they have questions about it.
Thank you. Jocelyn, you've seen some companies repackaging their DEI initiatives in the wake of Students for Fair Admissions. How so?
I want to be clear that the repackaging, it's not about adjusting a title or changing the goal, but rather broadening the perspective on what DEI means. So there have been programs in terms of racial criteria, and of course that criteria and language is susceptible to challenge. What we know is that employment decisions cannot be based on protected characteristics. But I think what we've seen is a broadening and deepening of our perspective on what diversity means. So for example, first-generation lawyers, people who have faced barriers in their field, people from different socioeconomic backgrounds, they all bring diversity to the table. And so what we've seen is programs start to account for that and really broaden what it means to have a diverse workforce. I actually think that has been a very positive outcome of what we've seen, which is that we've started to appreciate more of the different perspectives that come from different backgrounds. And what we've seen is that really just increases the diversity of thought that we have in the workplace, which can be just as important. In terms of which initiatives survive, I think we can very much say that there have been different views in different geographic locations. But what we know for sure is that the challenges have focused on the nexus to race, meaning that you cannot have a program that is race exclusive. And there have been arguments that certain criteria are just a proxy for race. But if we circle back to thinking about broadening our perspectives on diversity and the goals of programs to increase diversity of thought, then we're in a better position to defend against challenges to those programs and certainly continue to working toward those goals without the threat.
Okay, we have a request from one of our folks in the audience to share examples of appropriate DEIA programs and policies. Let's dig in there. Rawls, you mentioned unconscious bias in the corporate DEI training initiative realm. Jocelyn, just so we have a baseline definition here, what is unconscious or implicit bias?
So unconscious or implicit bias is the idea that over hundreds of thousands of years, the human brain has been trained to make snap decisions without all of the facts. We have to know that if we hear a sound at night, is it something threatening or is it not? So we make a snap decision on what to do before we actually know what the source of the sound is. That's the way our brains work. It's flight or fight. We need to know if it's a rabbit or a lion, right? How much in trouble are we? And so what happens over time is that, we just make decisions without considering all of the facts very often. And, we do that because we think very quickly, obviously. All of the neurons and synapses, what have you, are firing all at the same time. So we come to these conclusions often a little too quickly and without observing all of the objective evidence. I think implicit bias is another one of the words that has been misconstrued in order to support the challenge. And it has been misconstrued to mean that we are telling people that as a result of who they are, they have certain feelings about other races. I know that is not true at all. It's well known that that decision shouldn't be based on protected characteristics. But what the research tells us is that things like ethnic or female names on a resume lead to different results. We know that's the case. So we make assumptions on a subconscious level that we don't recognize that can have the same impact as explicit bias. So implicit bias is the level at which our brains operate that we're not conscious of. They're the snap decisions that we make without all of the information that's available to us. And we're not talking about just being automatically biased against a certain race or a certain group of people. We're talking about the idea that our brains make assumptions based on preconceived notions rather than the facts. And we can never eliminate bias or implicit bias from someone's brain. Our brain will always operate that way. Recognize when implicit bias is impacting a decision that we're making and have tools in place to not only be able to recognize that, but take steps to counteract that.
And so when you're advising employers about kind of incorporating this in their training, what is, for all of us, workplace implicit bias or sensitivity training?
Workplace implicit bias, it's about, like I mentioned, we're not gonna be able to eliminate implicit bias or change the way our brains work. But it's about identifying those instances or those situations in which we're making decisions without considering all of the facts. So we all know that there are countless stereotypes about certain groups of people, and sometimes the stereotypes can impact our decision-making when we're not considering all of the objective facts or the objective evidence before us. The important thing is focusing on the goal rather than the words. So for example, a training can be focused on effective hiring and retention practices. And that means relying on a full set of facts and not making assumptions. And I think, again, going back to this idea that some of the words have been misconstrued, I do think we have to walk away from some of those words to avoid the negative connotations and use words that are more reflective of our actual goals. So if we're talking about effective hiring, effective retention, and things of that nature, then that all stems from the same idea. Make decisions based on the objective facts. Don't make snap decisions or assumptions without considering all the facts. And so we're focusing on how we go about reaching the goal, what we can do, rather than this idea that there's something embedded in us that makes us bad people.
So Chair Burrows, what's your advice to companies who want to train on workplace implicit bias the right way?
Sure. Well, just really quickly, what I would say is it's really important to be clear that anti-discrimination training and implicit bias training are not necessarily the same thing. There are some trainings that combine them. And so I'll start with saying that it's important that employers conduct mandatory anti-discrimination training at some point, depending on the size and, sort of the workforce. would be tailored differently. And that really is a training that is focused on in being clear about, what obligations are, the respect that everyone deserves in the workplace, and, how to report and deal with violations when they come up. And it should really be focused on just practical goals of fairness and, how to deal with complaints, as opposed to notwithstanding that I think most of this audience is a lawyer audience. Notwithstanding that, I would say not focused on the boring sort of minutia of the law. While failing to provide that kind of anti-discrimination training is not a statutory violation of, obviously, training can help keep employers out of hot water and avoid legal jeopardy by helping employees, especially managers, supervisors, and HR professionals, know how to prevent discrimination and effectively address any complaints that may come up. So going back to this question of, so that's anti-discrimination training, to implicit bias training, which has already been defined in terms of understanding the ways that biases can creep in. That is something that an employer may decide that they need to do as well. And that's lawful. And so I would say, with respect to the commission's position on it, earlier this year, we voted and filed an amicus brief that I mentioned earlier, noting that anti-discrimination trainings that can include unconscious bias training, which was what was at issue, unconscious bias or implicit bias training was at issue in this particular case, Vavra v. Honeywell, can serve as really a vital measure to prevent or remedy workplace discrimination if it's done right. And with respect to that kind of training, implicit bias or unconscious bias, employers really need to be careful to consult with experts in the area and proceed thoughtfully, because I do believe that training in this area, as you saw from the Denver related case that the 10th Circuit decided, that was discussed at the top of this program, done wrong, it can rub people the wrong way. And even if it's lawful, it's counterproductive to do that, right? So it really needs to be thought through carefully. It can have value, but I think for looking at sort of some of the contours of what one could do in addition to the Colorado case that was discussed earlier, I would say Vavra v. Honeywell. In that instance, there was an employee who did not want to take the mandatory training, and he was eventually fired for not taking it. It included implicit bias that he objected to, and he claimed under Title VII a retaliation claim that he had raised a discriminatory claim. And what we and the court ultimately, without going into too much detail, made clear was that in order to raise that, there has to be some objectively reasonable basis for believing that the training was discriminatory. In this instance, the gentleman who filed the complaint, hadn't even opened the training. So he literally had no idea what it said, but nonetheless was objecting to it. So that really stands for the premise that per se, it's not unlawful to have implicit bias training. So that's the 7th Circuit in Vavra v. Honeywell. But I would say proceed with caution and very thoughtfully, and make sure you're working, if you're having someone outside do it, that you're working, whoever's creating this training for you and presenting it is really thoughtful about the broader context and how this will land, and to avoid stereotyping any particular group, painting with that kind of broad brush, while also addressing the really, salient and important issues. But I think that those would be the touchstones. Jocelyn,
from your vantage point, can implicit bias and sensitivity training be divorced from a company's workplace anti-discrimination training?
I think it can. I think it can be different things. I mean, I mentioned earlier reframing some of those trainings to focus on the goals rather than the issues we have to overcome. So if we're talking about respectful workplaces training, if we're talking about effective hiring and retention, then those types of trainings can address implicit bias and how they impact the things we do, say, the decisions that we make in the context of the workplace, without necessarily being married to anti-discrimination. I think that is a part of it. Our training often combines the two of them. But again, we have to think about these challenges and think about what is being challenged and how we best accomplish the goal by working within the reality of those challenges. And I think that's certainly one way to do it.
Jocelyn, should companies consider whether employee attendance at their workplace implicit bias and sensitivity training is mandatory?
I think companies should absolutely consider that. I think, one point that Chair Burrows made was that sometimes it can be off-putting for people. I actually had a comment in one bias training that I did some time ago from one of the participants that his negative reaction to implicit bias training was that he felt as though he was being told he was biased unless it was trained out of him. And so that was eye-opening for me just to see the impact of some of the programs on employees. So I think, what we've seen from some of the decisions that we've talked about is that there are people who feel uncomfortable. They assume these trainings are telling them something or saying something that they may not necessarily be saying. And so making those types of trainings voluntary, I completely agree. The anti-discrimination training should not be voluntary. That should be mandatory. But things like the implicit bias and the things that, we've seen people say make them uncomfortable, making it voluntary can certainly be helpful to mitigating that.
Maya, let's talk about the 10th Circuit's case for a moment. The 10th Circuit in the Colorado Department of Corrections case held that the employer's training materials standing alone were insufficient to show a hostile work environment. Might the 10th Circuit have come to a different conclusion if the employer had mandated additional in-person training using the same training materials?
I think that's possible. I think that the language itself was very pointed in a way that, if I was the Department of Corrections counsel, I would say we might want to change this. Apart from the point, I did want to note about the language of the training specifically, for example, that, white people created race as a way to oppress people. That is a very broad statement. And if you're going to go deeper into, the origins of race, similar to what Chair Burrows said, you want to have an expert to check your definitions and check your historical facts to make sure, one, it's accurate. And two, I think that there's a way that you can express, factual opinion or factuals that affect the workplace without kind of pitting one person against the other.
Okay, thank you. Let's turn to corporate DEI hiring initiatives. Jocelyn, you advise your clients trying to increase workforce diversity to think about the employee selection process as a funnel and to focus on the wide part of the funnel. Why?
The reason why is because hiring decisions can't be based on protected characteristics. So when we think about hiring DEI hiring programs, that creates the assumption that we are hiring based on diverse backgrounds. The funnel means that, when we increase the diversity of the candidate pool, we are naturally going to increase the diversity of the people being hired. So I look at the funnel as increasing the diversity of the candidate pool by thinking about where we're posting jobs. Are we posting jobs with some of the affinity groups that there are in certain professions? Are we posting jobs with the NBA? Are we posting jobs with women's bar associations? Making efforts to ensure that we're reaching diverse populations. If we increase the amount of diversity in the funnel, we are necessarily going to increase what we get out of that funnel. But the skinny part of the funnel is where we can no longer consider those different types of factors or those different backgrounds in terms of what we're doing to increase the diversity of the pool. So the skinny part of the funnel I see as who we're inviting back for interviews, who we're hiring and things of that nature. That cannot take protected characteristics into account. So we focus more on efforts that are meant to be inclusive rather than exclusive. So we can't advertise at one place to the detriment of another. We don't, we don't remove efforts to advertise at places that may be seen as less ethnically or background diverse in order to do so at places or with groups that are. So we focus on being inclusive of all backgrounds in the recruiting process and ensuring that we target candidates from diverse backgrounds. And then once we have that candidate pool, we, of course, take those protected characteristics out of the picture and make decisions, as always, based on merit and what someone can contribute to the work environment. But I think the ultimate goal is to really focus on recruiting and diversity in recruiting, and that will ultimately lead to a more diverse workforce.
Chair Burrows, may companies purposefully expand recruitment activities to attract a broader, more diverse applicant pool?
Yes, I think it's important that they do that, because otherwise you could end up leaving talent on the table, but also depending on what your recruitment is, if there are barriers that are, systematically in a broad way, not for, onesies and twosies, if you will, but in a broad way, denying that opportunity to apply, then you'll have a Title VII violation problem, potentially. So under the disparate impact standards under Title VII, that's, if you're advertising or recruiting in ways that really create barriers, not necessarily intentionally, that's not part of the standard, but just create barriers for other folks to find out about the opportunities, get their foot in the door, that could violate Title VII, depending on the specific facts. But, whether or not it's a broad enough problem to lead to an actual lawsuit, no employer wants to leave talent on the table that way. So I do believe it's important. It's something that we do within the federal government, as well as a matter of course under our regular procedures, so that we are sure that we are being fair and inclusive of all the talent that's in America.
Let's turn to corporate DEI fellowships that have been in the news lately. Jocelyn, how are companies altering eligibility criteria on their DEI fellowships to reduce the risk of violating anti-discrimination laws?
Sure. The risk of violating anti-discrimination laws comes from the nexus of a program to race. So race-based criteria is obviously problematic, but some of the anti-DEI groups have also been challenging the criteria that can be seen as a proxy for race. And so the way that we think about how to adjust those programs to accomplish the same goals, again, it goes back to broadening the idea, broadening what we think of as about diversity. So we may say, okay, there's a certain profession, African Americans or like Latino population is historically underrepresented. But let's think about the reason why. Let's take a step back, think about the reason why. The reason why might be because of socioeconomic background. The reason why may be because of lack of opportunities, lack of exposure. So if we ask people to talk about the barriers or the challenges that they have faced in their own professional development, then they may talk about some of those things that we've kind of shortcutted into what the impact has been and surpass what the cause of the impact has been. But asking about what are the challenges, what are the barriers that you faced in your profession? What have been the issues that you've seen with respect to growth and progression in a certain profession? We're going to see people that start talking about some of the socioeconomic factors, some of what they've experienced in their own backgrounds. And even in the SFFA decisions, we saw the court acknowledge that it may not be about race, but you can talk about how race has impacted you as an individual and how it has shaped your own personal experience. And that really, when you think about it, is what we care about. What has been the impact on your life, your experience, your progression in your career? So that is what I think of in terms of reworking some of the programs so that we still accomplish the goal. We are still diversifying a workforce and still committing to a diverse workforce, again, without using some of the terms, without using some of the criteria that has invited those challenges.
Let's turn to corporate DEI employee retention initiatives, and in particular, publishing corporate demographic data. Chair Burrows, may a company lawfully track the effects of its employment decisions on different demographic groups and publicize the results?
Sure. Title VII certainly permits, encourages actually employers to proactively evaluate their workforces to identify and remove any barriers to hiring, retention, or inclusion, and then to take action to prevent discrimination in the first place if they find such barriers. So there's no legal reason not to do it. Employers can collect and analyze workforce data to identify potential barriers to hiring candidates based on race, sex, age, or other demographic characteristics. And the federal government has been doing this for decades to understand what our workforce looks like. So it's up to the employer, of course, whether or not it will choose to publicize any results. But this kind of proactive review of workforce data is one of the best tools that an organization has for identifying discriminatory barriers before they become a bigger problem for employee morale, their brand, or even, frankly, a lawsuit. And the one thing I would say is that with respect to examining the workforce, not making an employment decision, but examining the workforce, looking at what we do in the federal government quite often and advise some of our counterparts to do, the EOC shares that technical experience with others, is to look at barrier analysis. So at each stage of the hiring process, of that funnel, if you will, to borrow the example earlier, how things turned out. So to be very clear, I completely agree that you're looking, if you're trying to broaden and be inclusive, you're really focusing your actions on that broad part of the funnel, who gets in the door to actually throw their hat in the ring and apply for your opportunities, right? But understanding what's going on in the rest of the funnel, just as an analysis, not your action, but your analysis, is important because you may discover that you have a discrimination problem along the way. And so that's one of the things. I'll give you an example. I'm not going to name names, but there was a barrier analysis where there was, sort of an employer that wasn't having, had a very non-diverse set of folks being hired in a particular area, and it didn't make sense given the broader, what you would expect in terms of the interest. And they assumed that they were not doing the right kind of recruitment. And it turned out that as you looked at each piece of it, people were getting in, they were passing the objective test and falling out at the interview stage, at the subjective stage. And so that was information that was useful in terms of making sure, are people being fair when they actually interview, when we've got candidates who've passed every objective qualification, same resumes, et cetera. And suddenly when the hiring officials actually see them face to face, they're not making it through. And so either as women, I can't remember exactly which group, but that, with respect to the analysis and just understanding what your workforce composition looks like, absolutely, you can look at that.
Thank you. Jocelyn, may a company base its managers' performance evaluations and its pay and promotion decisions on demographic diversity metrics?
Sure, I'll answer that question. And then I saw Maya had raised her hand for a second, so I'll kick it over to her. I think that would very likely be subject to challenge because the company is now creating an incentive to make decisions based on demographic backgrounds. So it's better to base rewards of that nature, rewards, compensation, bonuses on the goals. So instead of looking at the metrics, what does your team, what does your department look like in terms of diversity? We look at questions like, what have you done to expand opportunities? What have you done to support diversity in the past quarter or whatever the period of review is? And that way, we're making people think about what is my contribution been? What impact have I had? How have I helped expand the diversity on my team? And it encourages people to take action rather than just looking at metrics that they may or may not have any control over.
Maya?
I was just going to add to what Chair Burrows said regarding the barrier analysis and identifying that people were falling out at the subjective stage. This is particularly where implicit bias training can be helpful. And you can target it in a non-specific way. It helps everyone at the subjective stage to identify that if they hear a specific name or if they say, well, he or she just wasn't a good fit, that's not specific to, a white interviewer speaking to, a Black applicant or a Black interviewer speaking to a white interviewee. It can affect everyone. So I just wanted to point that out.
Thank you. Jocelyn, you advocate that corporations use labor economist research to undergird the rationale for their DEI initiatives. Can you tell us about this?
Sure. And I think this is in line with the earlier discussion about how looking at the population can be helpful. So we've seen over the years, and also what has been subject to challenge, some companies create goals such as, we want our workforce to reflect the communities in which we work or the communities that we serve. The issue there is that we don't necessarily know without research whether that's realistic. So if we say something like we would like 50% of our workforce to be women, we have to look at the available labor pool to make sure that's a realistic goal. If the available labor pool says in this job category or in this profession, there happen to be only 20% women, then there's no way, not no way, but there's likely not a lot of ways we can get to 50% women in that job category without presumably or circumstantially making decisions on the basis of gender. So having that research in terms of what's available in the labor pool, like from various backgrounds, like who is out there that we are recruiting, who are the candidates we likely have. If we don't have that research to back that up, then it's possible that we're creating a goal that's not realistic at all. But if we say, 50% of the available labor force is women, and so that goal of having a 50% workforce be women is attainable, it's realistic, it's achievable. The probability that the workforce is going to be 50% women, if we account for some of the things we've been discussing, like implicit bias, diversifying our interview panels to eliminate some of that bias, then probability alone supports the conclusion that there may not have been any decisions based on any protected characteristics, because probability would have it that there were 50% of the candidates available, and that's how it worked out in terms of hiring.
Jocelyn, thank you. Judge Edelman, let's talk about causation standards for a moment, one of which the U.S. Court of Appeals for the Fourth Circuit applied in finding that the company's DEI initiative there, in the case that Maya previewed for us, was evidence of racial animus. And I want to turn to our own DC Court of Appeals, because in 2022, the DC Court of Appeals in Rose versus United General Contractors recognized that the causation standard under Title VII was motivating factor. And then it went on to adopt a significant motivating reason causation for anti-discrimination provision in the DC Human Rights Act. In your mind, is there a difference either legally or factually between these two causation standards?
Well, thank you, Scott. It's a good question, and it's a fair question. But looking at that opinion, what's interesting about it is that language you quote, and just so everyone has the full benefit of it, talking about a case of proving discriminatory motive, perhaps in a mixed motive case, the court said a plaintiff's burden then is to show that a protected characteristic was a substantial factor in the employment decision. A substantial factor means that the protected characteristic was a significant motivating factor bringing about the employer's decision. And it quotes a Washington State Supreme Court case from 2014. To me, what's interesting about the opinion is that language sort of comes out of nowhere in terms of prior Court of Appeals precedent, and also doesn't really flow from the previous analysis in the opinion, which does talk about how our DC Human Rights Act is interpreted usually in accordance with Title VII. The emphasis of the opinion up to that point was to emphasize the statutory language in the DC Human Rights Act, which doesn't include anything about significant motivating factor, and also to sort of contrast what needs to be proven with a but-for standard and say that the plaintiff doesn't need to show that but for the discrimination, the challenge action would not have occurred. So while it's clear, and you focused on the sentence that does seem to impose some heightened standard, it's not clear to me from that the Court of Appeals was attempting to impose some sort of new causation standard, which is different from, as I said, the emphasis of the rest of the opinion, from the Title VII opinions, and from other cases, which you may well about to be asking me about.
So just from a practical standpoint, because you've presided over discrimination trials before, what advice do you have for trial lawyers in addressing that language, the significant motivating factor or reason language in the anti-discrimination provision of the DC Human Rights Act?
I mean, I guess, and I say this anecdotally, let me start with jurors. I don't know that jurors are going to be hung up on differences in language like that, differences in those words. It's certainly conceivable that you'd have a juror who wrestled with the concept of, what is a significant motivating factor as opposed to a motivating factor. I don't think that's going to overwhelm most lay people's view of, they see discriminatory motive and that's enough for them. In terms of how this often comes up, which would be, for example, in a motion for summary judgment, it's certainly my view, as reflected in my opinions, that considerations like this, whether a factor is substantial, for example, or whether a motivating factor is significant, is not something for the court to be resolving on summary judgment. Those are subjective words, and that's what we normally leave to juries. So it's my view that's the, again, this is not a personal opinion, it's reflected in what I've written and published, that those type of words are not ripe for determination by summary judgment.
Let's turn to retaliation. Judge Edelman, the DC Human Rights Act also prohibits retaliation for opposing an employment practice that is prohibited by the Act. And in Arthur Young versus Sutherland, the DC Court of Appeals adopted a, quote, factor that contributed to the defendant's action causation standard. In your mind, is there a difference, either legally or factually, between significant motivating factor or reason and a factor contributing to the defendant's action causation standard?
Those words are different. And it, again, if you're reading the language in Rose that you've just cited as creating some sort of heightened standard for causation, I guess one could make an argument that there is a difference. But again, that there shouldn't be a difference. I mean, the Human Rights Act, whether we're talking about discrimination or retaliation, doesn't contemplate a distinction in terms of what the standard should be between those two types of claims. So again, is this an argument that Rose was not intending to create a different standard? Is it an argument that a three-judge panel in Rose was legally unable to change the pleading standard if the pleading standard is established or a causation standard is established in Arthur Young and a more recent case, Tingling-Clemens? Perhaps those are arguments for the lawyers to be made in the future. And I think you've identified where there's some points of tension currently in our local law regarding this issue.
So let's talk about how these cases are proved. Evidence of pretext supporting an inference of unlawful discrimination. Judge Edelman, the Novad Health Court referred to multiple forms of pretext evidence that it said was indicative of unlawful discrimination in that case. I mean, as a judge who's presided over many discrimination cases that relied on pretext evidence as evidence of an employer's unlawful animus. Which forms of pretext evidence are the most probative and persuasive for jurors from your perspective?
So I think in general, this evidence of pretext is often the most powerful evidence of discrimination, that there's rarely direct evidence. It's often this type of circumstantial evidence. I think in terms of, again, anecdotally from the cases that have been brought and tried in front of me, the types of evidence showing pretext that can be the most powerful include, first of all, when a business in making a decision or government agency in making a decision deviates from its standard business practices, and there can be some proof of that, where there is a rationalization after the fact. In other words, there's nothing contemporaneous that shows that a decision was made for a certain reason, but after the fact, rationalizations appear, including after the fact in litigation itself, where there's investigation into supposed misconduct by the employee, and that's given as the basis for the action, but the investigation is in some way so haphazard to make that explanation implausible. And in general, jurors in the age where everything seems to be embodied in an email or text, where there is not contemporaneous documentation of the supposed non-discriminatory reason, that can be extremely powerful evidence of pretext.
Thank you. There's a maximum employment law, and that is that if it's not in writing, it didn't happen. Have you kind of seen that with jurors who are looking at a case where there's no contemporaneous documentation?
You know, I know the lawyers on this call that practice in the district know that our jurors are skeptical. That's something that prosecutors in criminal cases complain about. It's something that plaintiffs' lawyers complain about here too. So yes, if people expect that there's going to be something in writing, and if there's not something in writing or something contemporaneously reported, then they have a lot of skepticism about the claim.
So Maya, I want to come full circle here and come back to you as a employee side lawyer. You've had employees who come to you saying that an employer's DEI program created a hostile work environment for them, or that an employer treated them adversely in the wake of a DEI initiative. Just give us a couple examples.
So one of them was kind of what we would call a reverse discrimination claim. And in that case, it was similar. There were DEI programs that were trying to basically effectuate trainings for implicit bias and things like that. And the potential client basically said, look, I feel like, I'm being targeted. I get along with everyone. They keep asking me whether I'm going to this training. And I basically told her, I understand your discomfort, but there wasn't any language in the particular training that she was experienced discomfort with that targeted her independently or really targeted any of her protected classes. And so, I told her she can reach out to a management official if it makes her feel uncomfortable. But what I've seen is in line with what Jocelyn and Chair Burrows has said, that if the training isn't specifically pointed to, one race over the other, then that typically is not going to lead to a great case.
Thank you. Jocelyn, I want to pose to you one of the questions from the audience. National SHRM, the Society for Human Resources Management, recently dropped the E from DEI. What's your view of that and the decision to drop the E from DEI?
Yeah, I know you've heard me say this a couple of times, but I think it goes back to this idea that some of the words that we use are being misconstrued. And I think that is certainly one of the ones that's being misconstrued. And the narrative is that it means that people are being given an unfair advantage. The difference between equity and equality is that equality means that, we both start at the starting line. no matter what our backgrounds are, no matter what our socioeconomic experience has been. Equity means that because I may come from a disadvantaged background, I'm starting maybe a little bit ahead to account for that disadvantage so that we're on the same playing field. And some people see that as an unfair advantage. I think, considering our history, accounting for, the fact that some people are disadvantaged, to put them on the same playing field, I think is the right goal, and it's the right thing to do. But again, unfortunately, the word has been misconstrued to suggest that it's something that I don't agree that it is. And that's, another reason that I think we're seeing a pull back from that.
We also have a request to identify the parameters of good DEI training versus DEI training maybe that might run afoul of the law. Can you give us just a quick, maybe top 3 things to think about, Jocelyn, when a company is looking to kind of reanalyze its DEI program?
Sure. I think Maya just hit on one of the main things, and that is, do the programs have some sort of personal specific impact? I mean, do the trainings target someone and assume that they think a certain way or act a certain way as a result of their background? I think the main thing to think about is, one, how do we reformat trainings? How do we reformat programs so that we're avoiding or at least mitigating some of the legal challenges to those programs? So moving away from any nexus to a protected characteristic and broadening, the idea and the perspective on what diversity is. So I think making DEI programs open to everyone, making them programs that focus on different lenses and different perspectives of diversity is important. I don't think we need to pull back from the goals. I think we just need to approach them in a way that considers the environment that we're in and the challenges that we faced.
Thank you. We are ready for final thoughts. Maya, start us off. Final thoughts.
Well, first, I just wanted to thank everyone for joining today and the panelists for participating. I think that ultimately DEI programs are important to a healthy workforce. I think that, there are more strategic ways to get to the goals that might not have been as challenging before. And I'm encouraged by this panel to know that I think we might get to those goals regardless of how we get there.
Maya, thank you. Jocelyn?
I'll close with a response to one of the questions in the Q&A, which is, can the applicants themselves talk about race in their responses? I don't think it'll be a surprise to anyone that I identify as a Black woman. I have always. There haven't been any exceptions to that on any day. And that very much has shaped my experience. It has shaped my practice and the impact that I can have. But it does not mean that I don't have the qualifications and the education and the ability to do the same job as anyone else. So I think talking about background and the impact that we have had on our experience is absolutely okay and welcome, and doesn't mean that ultimately a decision is going to be based on that.
Jocelyn, thank you. Chair Burrows, final thoughts.
Sure. Well, thank you, first of all, to the host organizations for inviting me to participate in today's webinar and for your attention to this really, really important issue. Last month, of course, we celebrated the 60th anniversary of the Civil Rights Act of 1964. And really, since the passage of the statute, our society has been making tremendous strides towards equality in the workplace and that basic value of fairness that is so important to the fabric of this nation. Since the Act's passage, our society has made those strides, has continued that journey, not perfectly, not finished yet, but the EEOC's experience enforcing Title VII has made clear that there's a lot of work still left to be done to really fulfill the promise of equality for all of America's workers. And frankly, diversity, equity, inclusion, and accessibility practices that are designed to include qualified workers and help employers prevent discrimination and harassment by ensuring that every employee has a full and equal opportunity to participate is really good for the economy, for the strength of our democracy, and frankly, was intended as part of how the statutory framework should work. Because, of course, we are proud of the fact that we do an effective job of enforcing the law as a backstop, but it's much better if folks are leaning in, responsible employers of good faith are trying in the first place to ensure that that is unnecessary because the violations don't happen. And so everyone really deserves dignity and respect in the workplace. And at the EEOC, we are going to continue using all of our tools, enforcement, outreach, and education, policy litigation, to make that a reality, but want to be clear, and this I'm speaking for myself, but also with the knowledge that a majority of the commission has really leaned into making sure it's clear that our statutes allow effective and carefully implemented DEIA programs. So I think together as a country and all of us as employment lawyers can really move away from what divides us and towards a shared vision of equality and justice. So I thank you for your time and your attention, and really have enjoyed being able to be part of this conversation.
Chair Burrows, thank you. Judge Edelman.
Oh, I also want to thank the host for putting this panel together, and I also want to thank my fellow panelists for their preparation, their insights today. So much of our profession contributes in so many ways in our community, and I don't mean to denigrate the work of anybody else by singling out the members of MWELA who are here today and the employment lawyers who are involved in representing plaintiffs in these cases. Again, lawyers on both sides of the bar do tremendous work in making our profession an honorable one and in advancing the goals we've been talking about today. But I just want to talk a moment about lawyers who represent employees, because I know that in our court system and elsewhere, they don't necessarily feel that they get respected all the time. And I just want to thank everyone who is involved in that work for the work they do. We can have as many statutes and regulations and policies as we want, but without lawyers who are willing to take the risks that many of you take to represent plaintiffs in these cases, those don't mean anything. I know that there are a lot of challenges in this work, a lot of the challenges created by courts that we've talked today, but I, for one, am interested to see how you rise to those challenges in the future and continue to do the excellent work you've been doing. So again, thanks to Scott and MWELA and everyone else for putting this panel together.
Judge Edelman, thank you. Rawle?
Thank you, Scott, and I want to end as we began by thanking this esteemed panel for making time and sharing such great insights with this audience. It has been a privilege for the Bar Association of the District of Columbia to be a part of this collaborative. This isn't the first time we've worked with MWELA, and we hope to find other opportunities to do so. As we move from here, knowing that we couldn't cover the entire landscape, there were representations made by our panelists about what are we doing about and for the underrepresented. And I don't care from where you come or from where you're going, we all thrive. We all thrive when we feel seen. And if we're doing things intentionally or unconsciously to make sure people never get seen or don't have an opportunity to be seen, we're not going to achieve our promise in any industry that we're trying to do maximum impact work about. So again, want to thank this panel, want to thank MWELA for the opportunity to collaborate, and wish you all Godspeed as we move forward.
Rawle, thank you. Mary, you get our final word.
All right. Well, I guess I will also thank the panelists and MWELA for organizing this presentation. I'm not an employment lawyer, but I sometimes overlap with these issues in my work. I'm in-house, and I'll just say I took away a lot of great new knowledge as someone who follows, but not in the weeds on this topic. And frankly, am somewhat comforted to hear that a lot of what we hold dear with respect to DEIA programs is something that employers are still able to pursue. They'll just, need our legal help to make sure that they're staying on the right side of it. So I thank you very much. The Women's Bar Association thanks you, and I'll pass it back to Scott.
Mary, thank you. Thanks to EEOC Chair Charlotte Burrows, Judge Todd Edelman, and Jocelyn Cuttino, and a special thanks to Maya Jefferson, who organized this webinar for us. Thank you to Wiley Adams, Mary Blatch, Rawle Andrews Jr., and our co-sponsors for today's program, the National Bar Association, the Women's Bar Association, and the Bar Association of the District of Columbia. Mark your calendars for the Metropolitan Washington Employment Lawyers Association's October webinar. It's on Thursday, October 3rd at 12 p.m. Eastern. What trial lawyers need to know about appellate practice in Virginia, featuring Virginia Supreme Court Justice Stephen McCullough. We look forward to seeing you then. Thanks for joining us today.